You may proceed.
Mr. Chief Justice Young, Your Honors, may it please this honorable court, my name is Timothy P. Flynn. I practice in Clarkston, Michigan. I'm one of a small group of lawyers that occasionally, when the Oakland County prosecutor loses a motion or has some adverse ruling, the court administrator appoints me to serve as the appellee's attorney, and that's why I'm here today. This is a search and seizure case. The facts are simple enough. What stems from those facts, though, I think gives rise to some very important aspects of our law. This was a case where the local drug interdiction unit known as NET was lying in wait for a Mr. Leroy Jackson. And the interesting thing about the case is we can take a probable cause approach to this as Judge Anderson did, or I think that the prosecutor would rather have you roll this back and take more of a reasonable suspicion approach. But the significant facts here, I think that somehow, I think four of you voted to have this oral argument on application, and I think why we're here today is because Mr. Robertson, at the time he was seized, was standing next to Mr. Jackson. The NET unit did see him arrive to the Pontiac bus station along Woodward there with Mr. Jackson. We know that. He got out of the car and he's standing there. What I think is really significant, though, is the testimony in the case, the only witness that, well, the only significant witness, Officer Jennings, that testified in front of Judge Anderson, is that he made a decision within, his words are, under a minute, based on a feeling he had that something was wrong, which I'm going to suggest to you was nothing more than a hunch, to put the man in cuffs, to put Mr. Robertson in cuffs. And then from there, things started to proceed. Now, what I want to suggest to the court is that this case, this is that classic bifurcated standard of review, and I want to back up and talk about that just for a minute. Obviously, this court, when we're dealing with constitutional issues, is going to take a fresh look at everything, and that's the de novo component of this. I'm going to suggest to you, though, the Court of Appeals, if you really look carefully at their opinion, if you roll it back and take a look at what Judge Martha Anderson did in her 7 or 8 page, 9 page opinion and order, she actually made a finding of fact, a couple of them. The key finding of fact that she makes is that what Officer Jennings did constituted more than a Terry pat-down style intervention, but rather that Officer Jennings conducted a search, and it gets us into her whole probable cause analysis. That finding of fact was reversed at the intermediate appellate level. So it's not just a de novo review. I think the first thing we got to get past is the fact that the Court of Appeals said to Martha Anderson, Judge Anderson, you got that wrong. And I think that it does, that it's useful in the analysis of this case to just take a brief moment to see what this clear error standard really is. It's my first time appearing before this tribunal, although I have had many occasions to appear at the Court of Appeals, and one of the judges recently retired down there, Judge Whitbeck, he had indicated that this clear error standard is something that's easy to cite, but really he calls it a slogan. And he says it's really, a lot of courts cite to that standard, but without erudition. And what I want to point out to this high court is that Judge Anderson, under Michigan Court Rule 2.613C, is to be given the benefit of at least being the jurist involved with assessing Officer Jennings' testimony with regard to what he did. And when these are his words, not mine. When he's testifying, he says, I was troubled. I think the exact words he used was that he had a feeling that something was wrong relative to Mr. Robertson. Well, in her opinion at page 9, Judge Anderson says that this was not a pat-down search, it was a full-on search, meaning that probable cause would be required relative to Mr. Robertson. So that gets tossed out.
What impact did the sequence have? I mean, ultimately he had an ID that was not a valid ID. The search was conducted before the check of the ID. What would the sequencing have been if it had been different?
The sequencing is very important here if the Fourth Amendment's search and seizure clause is to mean anything at all, Your Honor. And the reason I say that is the first thing about this sequence that you raise is, are we looking at this from a probable cause perspective or a reasonable suspicion? Either way, I think that Mr. Robertson should have his order granting his motion to suppress the evidence upheld. And this is why. The officer's testimony is less than a minute after he stops Robertson, less than a minute. And what they knew at that point in time was that he's standing next to Mr. Leroy Jackson. He puts cuffs on him. So right off the bat, right there, if you're going to take a reasonable suspicion approach to this, I'm going to suggest to you that every single one of these reasonable suspicion cases that this Court has decided and that the United States Supreme Court has decided have a big difference between Mr. Robertson's scenario and these, all the myriad factual case law that comes up and results in these search and seizure cases. And that is that the net unit was looking at Mr. Jackson. But all of a sudden, within a minute, my client's handcuffed. So then you move the clock forward. We now have drug-sniffing dogs that come in. Okay, well, and let me back it up a little bit further. There was no heroin found on Mr. Jackson. So that's the first thing that happens after my client's handcuffed. And then the second thing is these drug-sniffing dogs appear, and they alert positive to the men's bags.
Then what did your client say?
Then my client starts talking about, then the officer comes back, asks him, gee, why did the dog alert on your bag, Mr. Robertson? He says, well, maybe I was smoking pot that day.
Crime.
But I think there's a corpus delicti issue there. I think that this Court, I think the case is McMahon.
If we're just talking about what then the officer is likely to do when somebody admits to a crime, what happens now?
Well, what you've got there
may not mean if this is if he should have been Mirandized at this point, you may not be able to use his statement, I was smoking pot. But why would the subsequent actions be precluded, including the pat-down that occurred once he says, hey, I committed a crime?
I think that, again, I think you've got People v. McManus issue here with corpus delicti, where if you're going to have, as you say, a crime, my guy makes an admission.
Yeah.
That admission cannot be used to establish the corpus delicti of a crime. So I think that there's a problem with that.
Well, the corpus delicti of the crime, I mean, at that point, he says he gets patted down, right?
No, at that point, once he says that, he's not patted down, I would say. Judge Anderson found that he was searched. And if you look at the testimony, he was searched. Yeah, it wasn't just a pat down.
All right, he gets searched.
This
and
record,
then they find the heroin, right?
Right. But
okay.
Again,
now, why do you?
Go ahead,
if there was insufficient basis to use his statement, it wasn't Mirandized, how do we get to suppress the actual evidence?
Because there was no probable cause, okay? The drugs, by the way, the bags were searched after this canine hit. Mm-hmm. Nothing found there.
Yes.
And I'm going to argue to this panel, to this Court, the probable cause, whatever may have existed, dissipated at that point in time.
Okay. Now, what happens when they figure out the guy patting him down or searching him for you didn't know at that point that the identity he'd given them was false? But do you think there's any way, once the officer who retrieved the heroin would have released him if he found out that, without further involvement, if they found out that he had submitted a...
I want to make sure I understand your question, Justice Young.
I'm talking essentially about the inevitability that this heroin would have been found and seized.
No, I think that if you take a reasonable suspicion approach, once the dog hit positive and they search those bags and there's no heroin, the fact that he gave, my guy's riding dirty, he gives he lies to the police, and he's got outstanding warrants. So he's not the best candidate here, but I think really what we're talking about is the public interest that we all have, our freedoms in the Fourth Amendment. And what I think should have happened after the bags were searched is he's free to go on his way.
And not until look, he's given an ID card, right?
Right.
Once that shows up as false, that certainly gives the police reason to continue to be interested in this fellow, doesn't it?
It would, however, in this case, he didn't have one of his colleagues running that ID. That was not found out till the seizure of the evidence had been made, and he's back at the police station.
But why isn't it a problem for you under the inevitable discovery doctrine? They were going to, even if they just waited until if they had, done it the right way, they would have figured out that he submitted a false ID and that was a crime. And so then they would have gotten to the search legally. So why do you not have a problem under the inevitable discovery doctrine?
Because under any of the case law, there was not enough facts here by the time he was seized with the handcuffs if you're going to take a reasonable suspicion approach. And if you take a probable cause approach, once those bags in the bus station turned up clean of drugs, probable cause is dissipated at that point in time. There is not an inevitable discovery issue here, I would submit to you, under either analysis.
But isn't he obligated to provide ID when they ask him under the current law?
I believe that the police certainly have the power to ask questions, but there is case law that says we can sail right on by without answering those questions.
But if you answer them falsely, there are consequences.
And once they provide the ID card...
That was not known, though. And I think the analysis is, Justice Viviano, Justice Young, is that the Florida v. RL case, it's cited in a couple of the opinions in our briefs, the point in time, if you're going to look at a reasonable suspicion analysis, is when the stop is made, what did the police know? At that point in time, we're arguing if you're going to use that approach, the reasonable suspicion, the roll it back and use this lesser evidentiary standard, then at the point in time that he was handcuffed, which as Officer Jennings says was less than a minute, what did they know? The man is standing next to a Leroy Jackson who was under suspicion. They saw him get out of a car. He looked nervous. Okay. Then you get into, the brother counsel spends a lot of power of juice on his brief to suggest to this court that this is a drug courier profile type case, the nervousness. I want to just point out that and I didn't cite them in my brief, but I want to take just a moment to suggest to the panel that the nervousness has been found by the Sixth Circuit to be a factor that we should give very little weight to, and I'm looking at the U.S. v. Richardson case from 2004. Also, U.S. v. Bell and U.S. v. Ureta. Those are all Sixth Circuit cases that suggest that seeming nervousness should be given little weight, and that in this brief for the prosecutor is a great factor. And if you look at the Court of Appeals decision, nervousness coupled with the fact that he's proximate to Mr. Jackson is something that they really seem to hang their hat on. The other case that I think this falls on all fours with, there was a case that Judge Anderson cited, and the people make great use of this case, People v. Arterberry. And that's your classic Detroit drug house case where you have an informant, a confidential informant, you got a search warrant. So on those grounds, it's completely different on its facts. But one case that I want to point out, because I didn't make great mention of it in my supplemental brief, that's the case of Ybarra v. Illinois. I think that case is on all fours here, where you've got a search warrant for a bartender. He's in a bar. Police come in and execute the warrant for the bartender, and they search the bar for heroin. In the process of doing that, they conduct a Terry pat-down of every single patron in the bar. They come up with Mr. Ybarra. They do a pat-down search. They go to other patrons. They come back to Mr. Ybarra, and they find the heroin in a crumpled-up pack of cigarettes. That conviction was thrown out. And that's similar to what you have going on here.
Well, no, but why is it? So Mr. Ybarra just shows up at a bar to have a drink. And Ybarra stands for the proposition that you can't just search everybody in the bar But your guy shows up with the guy about whom they have a tip, right? They show up in the same car. So he's different than Mr. Ybarra, right?
I think that just as this patron was merely present in the bar, my client was merely present and proximate to Mr. Jackson.
Except he showed up with the guy about whom the police had a tip, and the tip otherwise proved to be reliable?
With all due respect, Your Honor, I think you're suggesting some guilt by association type of analysis, and I think we got to roll it back and look at reasonable suspicion. So anybody that shows up with Mr. Jackson, whether it was his aunt, his mother, myself, we're traveling, maybe we got to go to court or something, we're all under a cloud, that means that the Fourth Amendment really doesn't mean anything from our view.
Thank you.
Good afternoon, Mr. Chief Justice, and may it please the Court. Joshua J. Miller, Assistant Prosecuting Attorney from the Oakland County Prosecutor's Office on behalf of the people. With me at council table is Mr. Thomas Gurdon, who's the Chief of the Appellate Division at my office. The people are respectfully asking this Court to deny the application because the Court of Appeals' unanimous opinion in this particular case correctly applied the law to the facts of this case and correctly reinstated the charge. The Court of Appeals' opinion really recognized that the officers in this case, after they verified several of the details of the Crime Stoppers tip, reasonably and ultimately rightly suspected that the defendant and his traveling companion were involved in trafficking heroin. They drew inferences and made deductions based on their background knowledge and experience, which in turn informed their actual observations of what happened in this case, which a lot of has been glossed over so far today. And this Court has said in People v. Nelson that is proper action for the officers to do. The officers then diligently pursued a means of investigation that were going to quickly confirm or dispel their suspicions and resolve any ambiguity as to whether the defendant's conduct was innocent or guilty. Now, in fact, within 10 minutes, the officers had developed probable cause to arrest the defendant. A drug-sniffing dog alerted on the defendant's bag, which was sitting in the open lobby of a public transit center. And the defendant and Mr. Jackson both said defendant had been smoking marijuana recently. Moreover, before the defendant was even detained, before he was even approached by the officers, he had committed a misdemeanor, a one-year misdemeanor, by possessing a forged state ID card. He then gave that card to the officers, who were able to quickly confirm that that ID was not, in fact, issued by the state of Michigan. And at the same time that confirmation was occurring, the dog was in the lobby of the transit center alerting on the defendant's bag. So the Court of Appeals' ultimate conclusion, which was that this was a proper search incident to arrest because there was probable cause to arrest, was proper.
What was the probable cause based on?
There were three separate bases for probable cause to arrest. Number one, the false ID, which was sort of occurring.
Well, they don't know about that yet, right?
That might help you with inevitable discovery, but that didn't give him probable cause at the time.
Well,
what's your second
Not
choice?
at the time.
Second would be the positive alert by the dog.
Let me jump back in because I started this line of questioning. So
Sorry.
That's all right. The positive alert by the dog, isn't it a bad thing for law enforcement when they then find that there's nothing in the luggage? Or it seems like a strange thing to tell the defendant, you're pretty much out of luck if they find something, and you're out of luck if they don't. You're pretty much, as soon as there's the drug sniff, I understand the case law says if they do the drug sniff and they do nothing else, they can arrest the person, apparently. But once they go further and search, like you said, to dispel or confirm or dispel, didn't they dispel or dissipate the probable cause when they found nothing there?
No, Justice Viviano, they did not. Because what the U.S. Supreme Court recognized in the recent case of Florida versus Harris is that these are chemical substances. They're odors that are easily transferred. In Harris is actually the perfect example. In Harris, the dog alerted not on any particular container, it alerted on a door handle. So if we're looking at the very literal approach of you can only search what the dog alerted on, we're not going to find drugs in a door handle. But it leads to the conclusion that maybe the drugs are in the car, or maybe they are on the defendant's person. In fact, I believe it was Justice Kagan who wrote Harris, said that what likely was alerted on was the fact that Harris had been handling drugs and touched the door handle. So the fact that the dog doesn't, that there are no drugs in the bags is not conclusive. It merely heightens the inference that the drugs are going to be found on the defendant's person, especially when we're looking at the officer's background knowledge, which is, well, drug traffickers typically travel in pairs. And that is a fact that has been glossed over completely in the defendant's brief and argument, is the officers know how these people operate. And that is why it goes beyond mere presence as well, I would also point out.
So just so I understand your position, the search and not finding anything actually makes your case better?
In this particular instance, yes, because we're considering the totality of the circumstances. Now,
do you need the statement?
Pardon?
Do you need the statement? The statement, I was smoking drugs, smoking pot earlier today.
For the
in order to have probable cause. Or if he had never made the statement, what if we conclude that statement needed to be Mirandized and you couldn't use it?
Well, it would not, if it needed to be Mirandized, it would not come in at trial. Under Patain and Dickerson, that is the remedy for a
Right.
Miranda violation. So it's not necessary to probable cause, Justice Larson, but it also...
Is it relevant to probable cause? Isn't smoking marijuana a 90-day misdemeanor?
It is a 90-day misdemeanor, but it also...
So how does an admission to it provide probable cause for an arrest?
Because it also suggests that the defendant might have drugs on his person,
Okay,
especially
so
when a
not
drug
because he's
sniffing
admitted
dog.
to a crime, but because it leads you to
Something else.
Yes,
something
especially
else.
when a dog is alerting on the bag
Yeah,
at the same time.
similar.
So the dog, I know the dog is, the testimony about the dog was the dog is trained to detect on various kinds of drugs, and the Court of Appeals noted that fact. So the dog might have been alerting on marijuana, it might have been alerting on heroin.
The tip was related to heroin? I mean, such as it was, the tip is pretty weak, right? It's anonymous, related to somebody else. I mean, you didn't mention that as one of the bases for probable cause. But does it matter that the tip is related to heroin and the statement is related to marijuana?
No, because it's an evolving circumstance. They are going there looking for heroin. But the innocent details of the tip have been verified up to this point.
Is the probable cause related to the statement, you can arrest him because he committed a crime before, or now there's probable cause that he has marijuana on his person and is committing a crime now?
It would increase the probable cause that he might have marijuana on his, because it is a probability that he might have marijuana.
Why is it more likely if I used marijuana earlier in the day that I still have some quantity on my person, as opposed to making it more likely that I used it all up, or whatever else might be the case?
So we know you're cautious with this.
I just use a little at a time. Right? Concerned.
Well, that is, Justice Viviano, that is the point of probable cause, though, is either one might be likely. We don't need to prove that it is more likely than not that he still has marijuana on his person.
You don't? For probable cause? You don't have to show more likely than not?
No.
What's the
That would
standard?
be a preponderance standard.
What's the standard?
Probable cause is a reasonable probability of, I'm trying to get the words
That
correct.
a crime is committed and the defendant committed the crime.
Thank you, Justice Larson.
Let me ask one other question, now that I've been identified as a frugal.
Uses
I won't even say. I can't even say.
I'm sure it's
My mother might be watching, so I can't even make the joke. But in the modern era, we have a statute that provides circumstances under which someone can legally use marijuana. So does the fact that someone says, I used marijuana earlier today, provide probable cause on its own, irrespective of the potential corpus delicti problem later on that might come up in a legal motion? But does that provide probable cause in and of itself?
I think it still does, because...
Are the officers under any obligation to ask the next question, whether you have a license?
I don't think they are under any obligation at that point, because this Court has recognized marijuana is still an illegal Schedule I controlled substance. The Michigan Medical Marijuana Act is a narrow carve-out that provides legal immunity. Now, the officers might say they had arrested him for something related to marijuana. Maybe they would have later determined that he had a valid card and registry, and that would have been the end of this matter. But that does not negate the probable cause for them to take action at this point.
Do you need to establish probable cause to prevail?
In this instance, based on the fact that defendant's person was searched, I believe we do need to establish probable cause.
But what
yes.
about your inevitable discovery doctrine argument?
Well, the inevitable discovery doctrine relates to the false ID, the forged ID.
Yeah.
Why do you like that one?
And that if at the time they discover, before they release him, they discover that he's you've got a false ID, that leads them to
They're going to get there anyway.
discover.
Yes, that would be the exception. I was speaking in terms of establishing probable cause on the.
I asked whether you had to prevail on the probable cause in order to prevail ultimately here. And you said yes. Do you wish to revise your statement?
I misunderstood, Chief Justice Young. I thought we were still talking about the track with the dog sniff.
Look, you're not even arguing that you get to use his statement, I was smoking marijuana, in the case in chief, right?
Correct.
All you're trying to do is establish that he possessed or was somehow involved with heroin.
Yes.
And you've got the heroin out of this stop, correct?
Correct.
That's what you want to use at trial.
Yes.
So my question is, doesn't the inevitable discovery doctrine get you where you need to go?
Yes. Because the officers will inevitably discover, or Sergeant Jennings, who was the officer conducting the interview, will inevitably discover that the defendant has a forged ID. He's going to be arrested for that, and he will be searched incident to his arrest at that point.
Yeah, but when did they discover that it was a forged ID?
The two deputies who were conducting, what happened was Sergeant Jennings was given the ID by the defendant. He turned it over to Deputies Morton and Thomas, who took it over to their patrol cars. So while everything else is going on with the dog sniff, et cetera, those deputies are verifying whether the ID is legitimate or not.
And how long does that take?
Moments. They run it through the lien systems.
So it's all at the scene.
All at the scene.
They knew, but they didn't tell the officer who was interacting with the defendant.
Correct. Because by the time that they would have returned to tell Sergeant Jennings, he had already discovered the heroin.
Too efficient.
I see.
And so it just seems like a very fantastical proposition that...
So if he would have, so I think your opponent's argument is, look, once the dog alerted on the bag and they searched the bag, that broke the chain of probable cause. At that point, the officer should have let him go. And your point would be, yeah, but those guys were sitting in the car right there, and if they saw him walking away, they would have said, hey, whoa, false ID, and then they would have discovered it?
Correct, Justice Larson. It seems like a fantastical proposition that they are not going to bring the ID back to Sergeant Jennings and say, Sergeant, we have a problem. This is returning. The testimony, I think, it sort of understates exactly what the officers discovered. It wasn't that, okay, this is a legitimate ID, but there's nothing attached to it. It's returning as not issued by the state of Michigan.
Do you have anything else?
No, I do not.
Well, actually, because I have a question. At
Yes,
what
Justice
point
Garcia.
would you argue where the people say that this became custodial?
Pardon? I'm sorry.
When did this become custodial? This stop become a custodial?
At the point the defendant was placed in handcuffs is my argument.
So your contention would be that once the handcuffs were asserted, that was now custodial?
Well, he was not free to leave, which is, I guess, technically for Miranda purposes, because it's still a Terry stop, it is not custodial for Miranda purposes. However, he is not free to leave, so he, in a sense, is in custody at that point.
So what would have happened if he had said, no, I don't wish to have them search me? Because if I'm not mistaken, the transcripts indicated that the deputy indicated, I'm going to search you, okay? And there wasn't really a formal response to that. What if he had indicated that no?
Well, the sergeant's testimony was that he would not have searched him if defendant had said no. He would have continued pursuing other means of investigation at that point. Whether that would have actually occurred, I can't say. It would only be speculation.
And once again, the plurality decision in Patain stands for what precisely?
That if there is a Miranda violation, the vindication of the Miranda rights is to not introduce the statement at trial in the prosecution's case in chief. Dickerson says the same thing.
What would have happened if he had said at the point of it becoming custodial, he was placed in handcuffs, he was read as Miranda, and the detective or the deputy had indicated, I'm going to search you, okay, and he said, I want a lawyer. Based on my Miranda, nothing's happening until I speak to my attorney. I want a lawyer. Well, what would the consequence of that have been?
At that point, they can still search him because Miranda protects against statements. being used.
Right.
And so if he can't say anything at that point that can be used against him, the officers could still search him at that point if they had a basis to do so. Unless there are any other questions from the court?
Thank you very much.
Thank you very much.